Good morning everyone, and welcome to our latest webinar on the changes to the coronavirus job retention scheme. I hope you're all well and staying safe. For those who don't know me, I'm David Smith, Managing Partner of MHA Henderson Logie, and I'll be chairing this morning's webinar. Over the next 30 minutes, you'll hear from Avril, our payroll manager, and Louise, Mackie from our employer advisory team, as they recap what has happened so far with the job retention scheme, and we'll outline the upcoming changes. The key changes that we're going to focus on this morning are flexible furlough scheme, the changes to the job retention scheme grant levels, and what employers should be doing now. As you know, this continues to be a bit of a moving feast. The rules came out last Friday evening, but what's been missing to date has been the interpretation of the legal aspects to bring clarity for what can be claimed for and determining claim periods, etc. So to date, there have been no changes to the ACAS guidance on their website, but both CIPD and Law at Work have now updated their websites and produced template letters. So there is some movement going on. What we saw in March and April was that guidance continued to evolve, and we are expecting this to continue when the new system is implemented in the start of July. It's fair to say that what we cover this morning is likely to be subject to change. Avril and Louise will be covering the job retention scheme, the story so far, looking at key changes to the job retention scheme, so what flexible furlough means and how it works, government funding levels and the changes coming up over the next 4 months, and maternity and paternity rules. We'll also look at what employers need to do, so start planning for the next few months, including return to work plans. Consider if you as employers want or need to use the flexible furlough scheme, consulting with employees and discussing circumstances such as childcare and public transport, and considering new agreements for employees. After Avril and Louise have gone through the detail during the next 30 minutes, we'll then be joined by Fiona Doctor, our Head of HR Outsourcing, for a live Q&A at the end of the webinar. So please pose any questions that you have to our team using the Q&A function in the menu. It should be on the right hand side of the screen for you. You'll be able to pose your questions anonymously, and only the speakers will be able to see the questions that you do put on the webinar for us. So first, over to Louise to start proceedings.
Thank you, David. So we thought it would be helpful to recap where we are at the moment. So the job retention scheme was set up to, and still is, designed to help employers retain staff that would otherwise have lost their jobs. So currently employees need to be fully furloughed and therefore undertake no duties whilst on furlough. So employees that could be furloughed under the scheme were those that would have otherwise lost their jobs through no work being available, those that are shielding, and those that are dealing with having to care for others due to the COVID-19, and additionally those that would have gone off on sick leave. So employees can and will continue to be able to work for other employers provided the contract allows for this whilst they are on furlough. Also, holiday entitlement has and will also continue to accrue at normal schemes, so with employees being able to take holidays whilst on furlough. In these cases, the employer is responsible for making all top-up payments to ensure that the employee receives 100% pay for any holiday days that they take under the normal pay legislation. So the scheme is going to continue in its current format until the 30th of June. So under the scheme, you can reclaim 30% salary, you reclaim the employer's NIC on the furlough wage payment, and you can also reclaim the 3% pension contributions that relate to the furlough payment. And it will continue that no costs in relation to the top-up amounts can be reclaimed. So the scheme is going to change and it's going to close to new entrants on the 30th of June. So effectively, this means all staff members need to have completed at least a 3-week furlough period by the 30th of June in order to be furloughed again in the future. If they have not met this condition, they will continue to work as normal or otherwise agreed between yourselves, so they will not be able to use the scheme that starts on the 1st of July. Also quite importantly is that all claims that relate to the period up to the 30th of June, so under the current scheme, must be submitted to HMRC by the 30th of July. That is the cut-off period for those submissions under the current scheme. So that was just a quick recap as to where we currently are. I'm going to hand over to Avril, who's going to talk through the flexible furlough changes that are going to come into effect from the 1st of July. Avril.
Thanks, Louise. Okay, so good morning, everyone, and thank you so much for joining us today. As Louise mentioned, I'd like to go over the flexible furlough scheme. This is a major change to the current job retention scheme. David mentioned at the beginning that there's going to be further updates to this guidance in the coming days. But right now, what we can do is give you a high-level overview of this topic and tell you how things stand at the moment. So the headlines are, with effect from the 1st of July, employers can ask their employees to return to work part-time. This gives the employer more flexibility and helps them to transition their employees back to work. Flexible furlough periods can last for any amount of time now. There is no need for the 3-week minimum period that's currently in place. A flexible furlough arrangement is only available to employees who have previously been furloughed for at least 3 consecutive weeks. The number of employees you can claim for after the 1st of July is capped at the maximum you have previously claimed for. The claim periods are for a minimum of 7 days, and claims can no longer cross calendar months, so you may find that you need to submit more than one claim if your pay reference period crosses a month end. For example, if you pay your employees from 11th of July to the 10th of August, you must prepare a July claim and an August claim, but Louise will go into more detail about that. So that's the headlines of changes. So how does this work on a practical level? Once you've determined that you do require some or all of your employees to return on a part-time basis, you must hold some discussions with them and come to an agreement about their part-time working. And of course, there must be a signed agreement with them. The part-time working can be flexible. What I mean by that is your business needs need to be taken into account, but also take account of the employee's situation. For example, they may have childcare issues due to school closures that need to be considered. The arrangement or shift pattern should be agreed in advance. As mentioned, employees can only move on to flexible furlough once they've completed the 3-week furlough period under the old rules. For example, an employee who's furloughed on the 1st of June to the 19th of June can go straight onto a flexible furlough arrangement from the 1st of July. An employee who's been furloughed on the 15th of June, who obviously would previously have completed the 3-week furlough period, they would have to complete a 3-week furlough period from the 15th of June right through to the 6th of July before going on to a flexible furlough arrangement. So, how's this calculated? I don't want to start throwing figures at you, but what I'll do is I'll give you an overview of the calculation process. For each employee who is flexibly furloughed, employers need to work out the following: the employee's usual hours, then the actual hours that they work in a claim period, and then what must happen is they must calculate the furloughed hours for each claim period. It's not just a case of taking one figure from the other, there's a little bit of work involved. So good detailed record keeping is essential. I really cannot emphasise enough how much detail you need to go into by recording total hours, hours worked and hours furloughed. Now the way this is calculated is going to vary depending upon whether your employee has fixed or variable hours. The usual hours calculation is determined by the number of calendar days in the claim period, and the worked hours is determined by the actual working days in the claim period. So as I mentioned, it's not that straightforward, but we'll provide some worked examples on our website as a follow-up to this webinar. The good news is for employees that remain on full-time furlough, there's no need to work out their usual hours or furloughed hours. Their calculation remains based on the maximum wage amount allowable. So to sum up these changes and I guess the steps that you'll need to take, you need to determine your business need for the employees that you want to return part-time. You need to check which employees are actually eligible for flexible furlough arrangements. Then you need to come to an agreement with these employees for the hours that you want them to work and the hours that they can work. Also, that agreement needs to be a written signed agreement, not verbal. And essentially, you must keep good detailed week by week records of hours worked and the employees' usual hours, as this is needed for the claim. So that kind of sums up the changes in terms of flexible furlough. What I'm going to do now is hand over to Louise, who will tell you more about the upcoming changes to the job retention scheme.
Thanks, Avril. So, as we said, from the 1st of July, the new scheme is coming into effect. From what we've seen so far, there's no time length that's being set on the furlough periods. So at the moment, we don't think the 3-week period as it has currently stand will be in place. And as Avril's touched on, the claim periods are also going to be changing. So what we need you to do is you're trying to match all claims to your pay reference period. So this will be easy to do for calendar month pay reference periods, but for those that fall into the middle of the months, that will be a little bit more challenging. So the claims must relate to the calendar month that are submitted, and you cannot span a 2-month period. So if a pay period straddles the month end, 2 claims have to be submitted. A claim period will be for a minimum of 7 days. The only exception that HMRC will take to this is that if you're covering off the last or the first few days in the month end because of where your pay period ends. So that is something to watch out for when you're making your claims. Now, the actual changes that are coming into effect from the 1st of July regarding the amounts you can claim will change month by month as the level of the funding that is being issued is being reduced down. So from the 1st of July, all the amounts that can be reclaimed will stay the same under the current rules. So you will get your 80% wage reclaim, you'll get your NIC and pension furlough associated costs with those claims. If you're being flexible or furloughed with your staff members, those amounts will be proportioned down, as will the cap level. From the 1st of August, this is the main real change starting. The 80% of wage will still be paid by HMRC or up to the proportioned cap level, so depending on whichever is lower. However, no NIC or pension costs can be reclaimed from the 1st of August. These costs will now fully be payable by the employer, and this will continue until the end of the scheme. From the 1st of September, 70% of the 80% wage that is paid will be paid by HMRC, or the amount to the proportioned cap level. The employee must, however, be paid 80% as a minimum. Therefore, the balancing payment needs to be picked up by the business. And again, no NIC or pension costs will be covered. So these need to be picked up in full. From the 1st of October, the amount that can be reclaimed from the government again will reduce, and it will reduce to 60% of the 80% wage. And again, the employee still must be paid a minimum of 80%. So again, that difference will have to be picked up. Again, no NIC or pension costs. And then the scheme is expected to end on the 31st of October. So there will be, from the 1st of August, a sliding scale as to how much you will be able to reclaim, and that will give a bigger cash flow impact to the business as more and more amounts have to be paid. It's just their way of trying to engage more people back into the workplace. A couple of other matters I think that are quite important to cover off with the changes that are coming in is that there will be a cap on the number of employees that can be claimed per submission from the 1st of July. The number per claim will be based on the highest number of employees that were noted either on your March, April, May or June claim. So if you submitted a claim in May which had the highest number of furloughed employees of say 12, that is the most you can ever have on a claim going forward. So that is something you'll have to manage and work through from a planning perspective to ensure that you can get the maximum amount paid back from HMRC. Employees who start a 3-week furlough period that will span the 30th of June must complete this furlough cycle to qualify under the current rules. That employee, once that 3-week period has come to an end, can then move on to flexible furlough or stay fully furloughed, depending on what agreement's in place. Those returning from maternity leave can also be furloughed, provided the business has other qualifying furlough employees and that returning employee would have otherwise met all conditions apart from having been previously furloughed because they were on maternity leave. Also, those that are being TUPE'd over or transferring to a new PAYE reference after the 10th of June, so they wouldn't have met the furlough condition of a 3-week span by the end of the month, can still be furloughed under certain conditions having been met as well. So there is still the opportunity for those ones to be picked up on the furlough. I think the main impacts are obviously the tapering down of the relief that you can get back, and being very careful as to how you maintain your records for making your claims, because it will be important to ensure that you're claiming as much as possible and not missing out over the spanning months. So I'm going to pass back to Avril, who's going to cover off some of the important points that what you need to think of as an employer. Avril.
Thanks again, Louise. So as you might have gathered by now, everyone, there's lots and lots of planning to do. What I aim to do in this section is just to highlight some of the things you need to start to consider now, and also signpost you towards some further guidance that you may find useful. So the upcoming changes in July through to October really need careful consideration by employers. Remember, the job retention scheme ends on the 31st of October, as far as we know at the moment. So you should start thinking now about what's going to happen with you and your business and your employees between now and then. Start thinking about the workforce requirements you expect to have over the next 4 to 5 months, and how you can use the flexible furlough scheme from the 1st of July to your advantage as you transition back to the new normal. In planning ahead for staffing levels, consider the requirements for your employees either to be on full-time furlough or flexible furlough in the weeks ahead. It's advisable to do this now so that everyone knows what they're doing and, as far as possible, knows what to expect. Also, planning this now is going to give you time to get your agreements with your employees in place. I've mentioned this before, but I'm going to say it again because I can't emphasise how important this is. Create a good detailed system of tracking the hours worked and the hours furloughed. This really is vital. It's needed for your claim process. It's needed for payroll, and it's also needed for the records that you need to retain for 5 years. As Louise has touched on, and given in detail actually, the grant gradually tapers off. So as you're looking ahead to the next few months, you'll also need to consider the additional costs that you will have to bear in terms of furlough top-up costs, as well as employer pension and employer NIC costs, and consider what your business can afford and how you're going to meet these costs. So there's a lot of thinking and planning to do. In terms of employee agreements, as mentioned, the employers need to agree in advance with employees which days and hours they're going to be required to work, and then confirm that for the remainder of the working day or week they will be furloughed. The written agreement must be kept by you on file for 5 years. Now, if this arrangement is going to change week by week, Potentially the letter will need to be issued week by week, so planning ahead and getting the agreement right is absolutely key here. The agreement with your employees must be done in accordance with existing employment, equality and discrimination law. So you may require guidance on this, perhaps either via ACAS, maybe your current HR or legal advisor, or you're welcome to contact us if you do require help through this. On planning a return to work, current government guidance on social distancing must be taken into account when thinking about your employees coming back to the workplace. Employers should also consider how they approach the matter of flexible furlough with their employees. They may have childcare issues or other issues which might be a barrier to them returning to work flexibly. Additionally, flexible furlough could possibly leave some employees at a disadvantage financially, if you think about it, because their full-time furlough pay may be based on basic and overtime rates, and when they come back to work, their part-time pay is based on basic only. So that might be an objection you could meet from your employees. Careful consultation with your employees will usually resolve these matters, but please do seek further guidance if needed. Now, personally, I'm not an expert on these matters. However, I would recommend that you watch a recorded webinar on workforce and HR planning during COVID-19. This is presented by my colleagues Fiona Doctor and David Archibald. The information and guidance provided there is excellent, and the link to this webinar should hopefully now be showing for you. That's just about it from me, I think. I'd like to thank you for your time today, and I hope you found this presentation useful. Now, please watch our website for further guidance and further updates and details on this matter. I'm now going to hand you over to David for your questions.
Thanks, Avril, and thanks, Louise, too, for your insights this morning. I think the emphasis on good record keeping is a key message that we take away from this morning. I also look forward to seeing the worked examples to help us all understand the changes to the calculations and the cash flow impacts from that, and also help explain the processes that Avril and Louise are going through to get the payroll complete for you all and your claims submitted. I can see that there's quite a lot of questions, a lot of activity in the Q&A section already. So we have just more than 15 minutes or so that before we close the webinar. So I'll go straight to the first question, but please continue to keep posting your questions in the Q&A as we progress with answering the ones that are already submitted. So first one, I think this one will be for Fiona Doctor. A question about flexible furlough in terms of managing workload as we come out of lockdown. If, for example, we're busy on Mondays and Fridays, but quieter Tuesdays, Wednesdays and Thursdays, can we use flexible furlough and claim for Tuesdays, Wednesdays and Thursdays until our workload picks up?
Thanks, David, and good morning, everyone. The answer is yes. However, you are entering into a variation of contract with the employee, so you should discuss that with them. And as Avril has already highlighted, get that agreement in writing. Thank you.
Okay, thanks, Fiona. This one for Avril. As of April this year, variable workers' holidays are paid for based on a 52-week average. Will those on furlough be impacted by this negatively?
Thanks, David. The answer to that is yes, most likely, depending on the individual specific calculations and what their historical working hours are. It's likely to be that the holidays are going to be calculated going forward on a lower amount when we're working out the last 52-week average. And saying that, we're still awaiting further guidance on the holiday aspect of this. So I'm not saying that's set in stone, but as we understand things at the moment, the answer is yes, it can potentially negatively impact holiday entitlement. Thank you.
Super, thanks, Avril. Next one then, I'll go back to you, Fiona. I have an employee who has been working his or her normal hours during this whole period and has managed with childcare through the schools. He or she has currently not had an answer from the council regarding childcare over the school holidays and is wondering what their options for work will be if they can't get childcare from July to August. It's too late for furlough, but just wondering if the person can qualify for it in any way, since we have been open every day and require that person's attendance at work, but they can't work from home.
Thanks, David. I think we should be saying over when we've actually finished answering a question, so you know when to step back. I think it's a very difficult situation, and it's one that a lot of employers are having to face. And yeah, I think overall employers are trying to be as flexible as they possibly can. Obviously, as Avril and Louise have explained, it's difficult to, well, it's not possible to have any new entrants to the scheme effectively from the 10th of June, unless someone's returning from maternity or other family-friendly leave provisions. So if furlough's not an option, then other possible solutions might be varying work patterns and hours, taking annual leave or unpaid leave, or perhaps even an unpaid sabbatical if that was something that the employer would be willing to consider to help the employee through this period of time. Over. Thank you.
Thanks, Fiona. Thank you. Another one for you, Avril, then. If an employer decides to ask staff that are not furloughed to work 80% and be paid 80%, would this mean that someone who is furloughed and will then be flexi-furloughed be better off, as they would end up being paid more than 80% in the month? So could they be asked, for example, in October, that the 20% top-up, they are to only work the equivalent 20% of their hours, so that overall they still get paid 80%. Hope that made sense to you. I'll leave you to unmute.
I've done it again. I do apologise. So yes, the question did make sense to me, thanks. Yeah, it's a tricky situation, because if your working employees are on a reduced pay and you're saying you're bringing someone back on flexi furlough, are they getting paid more for a day's work than your current full-time working employees? Well, it's really down to negotiation. If you can, might be a tricky negotiation, but if you're saying to someone, I want you to come back flexibly but only want to pay you the same as you're getting paid for being at home, then that's difficult. But it potentially, you could have the situation where flexi furlough people are getting paid more than the full-time working, but it's all down to negotiation and agreement with your employee. Hopefully they'll be able to understand that you're trying to help you with the transition back, and they'd be willing to accept less favourable terms so that everybody's the same. But it's really down to negotiation. Over and out.
Thanks, Avril. Probably, Avril, just as a follow-up question then, will you be helping clients with working out an appropriate spreadsheet for dealing with flexi furlough and keeping track of hours, etc.?
Thanks, David. Yes, Louise and I have been discussing this, and it would be great if we could have a one-size-fits-all spreadsheet and give everybody a copy, but I don't think it's going to be that simple. But we're going to work on developing something, and we hope that it's going to be maybe a starting point for each client to develop, adapt it to their own needs. And we're quite happy to work with you to get something that works for everybody. So we've not got it yet, but we will get something developed.
Okay, thanks, Avril.
Okay.
And another one here, this one for Fiona. I'll find one for Louise shortly, I'm sure. This one for Fiona. Wondering how you deal with employees taking holidays while on the scheme. So say the employee returns to work 50% in August, September and October. Holiday has accrued as normal, 2 days per month in April, May, June and July, although the employee has worked at 0% hours. In September, the employee takes 1 week's holiday. Should this be counted as 2.5 days or 5 days holiday? Fiona.
Thanks, David. Excuse me. The relationship between flexible furlough, holidays and holiday pay is probably going to be a rather complex area. And unfortunately, we are still awaiting further guidance on this. So I think most that we can say at the moment is that we will update our website as soon as we actually get clearer guidance on that. Thank you.
Thanks, Fiona. I'll come back to you, Fiona, with the next one actually. So someone has handed in their notice during lockdown. They want to stay on furlough, but the employer would like to bring them back as required. Is that okay?
Thanks, David. I mean, the furlough scheme is in place for employers to support employees when there is no work or limited work available. So if there is work available, then unless there is a valid reason for declining to come back to work, then the employee should come back to work, if that makes sense. So what I'm basically meaning is that with the contract of employment in place, there's something called mutuality of obligation. So the employee accepts a wage for doing work, and obviously the employer is there to provide the work. So an employee cannot turn down any request to come to work unless there is a valid reason. And in this sort of situation, it may be due to health and safety concerns. So if there is valid health and safety concerns, then in that situation, the employer should talk to the employee to try to obviously alleviate those concerns so the employee does come back and completes the work during their notice period.
Thanks.
Sorry.
Yeah, thank you, Fiona. That was really clear. Thank you. Just probably a follow-up one to that, if that's okay. If an employee refuses to return to work, can they do that? And if so, what are they paid?
It's basically a similar response. I would be sitting down with the employee trying to establish why they are refusing to come back to work, why they're refusing to come back to work. And if there is a valid reason, then obviously work with them to reach a solution. If there is no valid reason, then effectively it becomes a disciplinary issue and needs to be dealt with via that process. So I wouldn't be automatically stopping the pay. I would be taking them through a disciplinary procedure to determine the outcome from that.
Okay, thank you, Fiona. So the questions coming in thick and fast, so we'll see if people are on their toes here. This one for Avril, maybe, we'll see. For record keeping of hours worked on flexible furlough scheme, would you advise this is recorded by employees on a timesheet, or can it be recorded by HR? I'll let you unmute first before.
I knew that. No, I didn't. Right, so I guess it's down to how your organisation works, what works best for you. As long as if it's recorded by the employee and agreed by the employer, signed off by the employer, that's absolutely fine. But if it's more suitable for HR to keep a record, then that's fine too. You've got to think though how this information is going to be, if you're using our payroll bureau, how's that information going to come over to payroll? Would it be ideal to send X number of timesheets to us? It'd be best if it was collated somewhere. So I think I'm saying what works best for you. is fine, as long as you've got good records and they're all agreed by the employer. Okay.
Thanks, Avril. Okay, the next one, well, maybe I'll throw this one to Louise, and we'll see whether there's some that we can answer in detail just now. Can we elaborate on the minimum 7-day claim period under the flexible furlough scheme? Does this mean that the new minimum furlough period will be 7 days rather than 3 weeks? I'll let you unmute, Louise. Don't know if Louise is hearing us. If not, well, maybe we jump to Avril. Oh, no, here we go.
Don't know if you can hear me. I'm kind of breaking up a little bit. So yeah, so the claim period doesn't have to be, or the furlough period doesn't have to be for 7 days. It's the claim period that is for 7 days. So that would suit people that are maybe on weekly pay, or if you want to do it.
Okay, maybe Avril, could you come in at all on that one, just if Louise is breaking up a bit there?
Sure, no problem. Right, so Louise started to say the 7-day period relates to the claim period, so it doesn't mean to say that the employee has to be furloughed for those 7 days. So even if the employee works 2 days out of that 7 days, then that stays within that claim period. I think the question surrounded the 3-week period too. So that doesn't stand anymore. The furlough period is based on 7 days now. So the 3-week requirement doesn't exist after the 1st of July. I think that answers the question. That's
super, thanks Avril. Just a couple more just before we wrap up then that have just come through. Maybe this one for Fiona. Can an employee be alternated between full-time furlough and flexible furlough as the workload requires?
Short answer is yes, they can. I mean, that's probably the one benefit of this new scheme, is that it's giving employers far greater flexibility to obviously try and bring the workforce back. Thanks.
Thanks, Fiona. I didn't even get time to mute myself before unmuting, so thank you for that succinct answer. So I'll come back to you for perhaps a slightly longer one. If workers normally work an 8-hour day, can you ask them to work for 2 hours per day? Which, if an employee normally works 8 hours per day, work for 2 hours per day and make up the salary to 100%?
Basically, the answer is that the same, yes, you can. But I mean, obviously, it needs to be discussed with the employee. Because it is a variation of contract again, so you need to get that employee's consent to that variation of hours. But the scheme does allow that flexibility.
Thanks very much, Fiona. There's actually a number more coming, and we do have a couple of minutes left, so I'll try and get through a few more. Avril, post July the 1st, can a statutory maternity pay returnee be added to the maximum number of furloughed employees, i.e. if the previous maximum number was 10, must they be included in the 10 or can they be the 11th?
In that situation, because they're returning from paternal leave, then yes, there's an exception there.
Okay, thank you.
Okay.
And I'll throw this one back to Fiona then. We are still paying 100%. Can we ask previously furloughed staff to take holidays and furlough them for the duration of the holiday?
You can ask your employees to take holiday whilst they're on furlough, and the obligation was that you did top up to 100%. So if this employer is actually paying 100% already, then that isn't an issue. If an employee isn't willing to to take the holiday. You can insist that they take holiday, but in that situation you have to give them double the notice to take that holiday period. So if you're wanting them to take 5 days holiday, then you would have to give them 10 days notice of that. Thank you.
Thanks, Fiona. Okay, I may be straight back to you, Fiona. Should everyone get a new flexible furlough agreement on the 1st of July, if you know they'll be fully furloughed in July, most of August, and then ramping up in September and October? The full details of hours will vary week to week.
Certainly the guidance that I have read today suggests that if the hours are varying, then yes, that you do need to actually give them new agreements, and you need to, if it is depending on the actual period of work, so say the hours are going to change weekly, then in theory you're meant to give them a new agreement on a weekly basis. But again, there will be more guidance coming out about this, so we can post it on our website. Thank you.
Okay, thanks, Fiona. I'll come back to you one more just now then. Our boss keeps telling people to switch off on a Friday afternoon. Can we agree this with them being furloughed for that period?
Sorry, David, can you repeat that? Because I was wondering if that was a message you were sending me on a Friday.
No, that's not a direct message from me to switch off on a Friday afternoon, but a boss keeps telling people to switch off on a Friday afternoon. Can we agree this is them being furloughed for that period?
No, I would. It doesn't feel as if it's in the spirit of the furlough scheme. I probably need to know a bit more about that before giving a definitive answer. Oh no, I'm sorry. Sorry, I thought it was on mute. I would need to know a bit more about that before I could give a proper guidance on that, but it certainly doesn't feel as if it's in the spirit of the furlough scheme. Okay,
and one more then. Avril, we'll end with you, big smiley face. If an employee was to come back 1 day a week, would the employer pay, say, 20% and be able to claim 60% through the job retention scheme?
Yes, if they have the correct flexible furlough agreement in place, then that's okay to do that.
Okay, thanks very much, Avril. There is one question there. Given the extra work involved in payroll, are accountants and payroll bureaus in general charging extra for this work? Well, as you'll know, anybody that's working with us on the job retention scheme claims, they're going under a separate engagement letter, and we're agreeing with each of you for the work involved in those claims. And we're working with our payroll clients on any additional work that we're doing through our payroll processing as well, and speaking to each client individually on that. So I think that covers every question that's come through. If there's any specific ones that you have that you want answered, that'd be one that you could come back directly to Louise in our employer advisory team, or Avril in the payroll team, or indeed Fiona in our HR team, to give you more specific advice beyond the general advice that we've given this morning. Just want to wrap up bang on time with thanking you all for joining us this morning for the webinar. Thank you to Avril, Louise and Fiona for your insights. As I said earlier, the direction on the new rules is likely to evolve over the coming days and weeks. So please be aware that aspects of what we've covered this morning are likely to change, and that we'll see more change coming over the summer. It's the nature of the world that we're living in. We just need to stay on our toes, like our presenters have been this morning with the questions that have come through. Keep your energy levels high and keep adapting to the change that's coming at us all the time just now. Thanks again, everyone. Stay healthy, stay safe, and we'll see you all again soon. Okay, bye now.